provider, president support, and would like to speak. Ms. Dennis, if you want to come up to the table, if we could make some way for her. And we do have green cards in support, but not wishing to speak, by Zach Daniels, the Executive Director of Louisiana District Attorneys Association, Darren Alamon with the Jefferson Parish DA's Office, and Brad Burgett, our District Attorney from the 7th Judicial District. Good morning, Ms. Dennis.
Good morning. My name is Jill Dennis, and I'm the Vice President of the Association of Supervised Ankle Monitoring Providers with over 20 years of experience in both pretrial and post-conviction supervision. I'm here to speak about strengthening victim protection in Louisiana. Under CCRP 320, courts already have authority to impose no contact orders, stay-away orders, and electronic monitoring conditions of release. When a victim protection is used correctly, it is not about a protection order, but real protection to victims. It is a two-part system. First, when a court determines that an offender's history and charge that GPS is appropriate, the device is installed prior to release. Second, when a victim is informed of this protection and consents, the court can make it a condition of release both pretrial and post-conviction so that before the offender is released, they are equipped with a protection tool, either an app on her phone or a dedicated receptor that connects directly to the device on the offender's ankle. The court can define a roving stay-away zone that follows the victim. If the boundary is violated, the victim is alerted. She can contact law enforcement by simply pressing a button within the app, and the offender's device emits a high decibel alarm. This is proactive protection, not reactive. Louisiana law already contemplates this in high-risk situations, but limits it to primarily first-degree rape. And that brings us to HB 125. HB 125 focuses on individuals in the state that's already identified as presenting elevated and in many cases the highest levels of risk based on the nature of the charge and prior history. HB 125 identifies specific charges where the court has already determined that risk is elevated and that supervision conditions may be appropriate. But what HB 125 does not currently do is ensure that victims receive protection. And that's where the gap is. What we are proposing is not a change to the authority of the court, but to align HB 125 with existing law so that when those charges are present, victim protection is part of the conversation at the time of release. This does not remove discretion. It does not mandate monitoring. It ensures victim protection is considered at the moment it matters the most. We have already decided as a state that this level of protection is necessary when the risk is the highest. The question today is whether we apply the same logic consistency when we know risk exists. Victims should not have to wait for a violation to be protected, because victim protection is not a feature of the system. It's a responsibility of it. Thank you, Madam Chair, for allowing me to speak. Thank you, committee.
Thank you, Ms. Dennis. The board is clear. We did receive one card